Bharat sir, we'll start, sir.
You can start, sir, no problem.
Yes, Azil sir, we'll start now. Azil sir, we can go live. We can start. A very good morning to all the participants. A warm greetings to all the participants from Christ Academy Institute for Advanced Studies. Christ Academy Institute for Advanced Studies, affiliated to Bangalore University, is a great academic fraternity formed as a part of precious CMI heritage and sustained by the earned life of knowledge. A special word of welcome to all the participants to the webinar on IPR and patent process, organized in collaboration with Rajiv Gandhi National Institute of Intellectual Property Management. The webinar aims to create first-level IPR awareness among the teachers about the beneficial aspects of patenting their creative and novel ideas. Such awareness would in turn be highly essential for the promotion of creativity, research, and technical advancements, as well as application in the market. And we are very privileged to have with us as our resource person, Dr. Bharat N Suryawanshi, Assistant Controller of Patents and Designs, Rajiv Gandhi National Institute of Intellectual Property Management, Nagpur, today with us. Sir has done his MSc from Gulbarga University, Karnataka, and has also done his MPhil from Gulbarga University. He is also PhD in bioefficacy and phytochemical studies from Marathwada University, Mumbai, Maharashtra. Sir has joined the Office of Patent and Designs in the year 2003 as an examiner of patent and also is trained on patent designs from Japan in the year 2007. He is also promoted as now the Assistant Controller of Patents and Designs in December 2012. He has attended many national trainings in India. He has delivered number of lectures in IPR programs in collaboration with colleges, universities, companies, biotech consortium on different topics. Sir, it is indeed privilege to have you with us as a resource person to deliver a talk on IPR and patent process. Hearty welcome again to you, sir. Advanced Studies. Over to you, sir.
Thank you. Good morning to everyone. This warm welcome you all to the session of intellectual property rights. Many of aware or may not, but many people are nowadays in the field of intellectual property. They're filing the research work, different kind of intellectual property and patents. Now, I'll deal with the intellectual property by sharing the slides. Yeah. Are you able to see my slides? Is it okay? Please give me the approval. Is it okay?
Yes, sir. Yes.
Yeah. So we the being working in the Ministry of Commerce and Industry, Department for Promotion of Industry and Trade, our office is called as Office of the Controller General of Patents, Designs, Trademarks, and Geography Indications. We are having different patent offices at different jurisdiction, that is Kolkata, New Delhi, Mumbai, and Chennai, wherein Patent Information System was earlier now renamed as Rajiv Gandhi National Institute of Intellectual Property Management is at Nagpur, Trademark Office at Mumbai, Kolkata, New Delhi, Chennai, and Ahmedabad, wherein GI, Geography Indication and Appellate Board is located at the Chennai. This is a picture review of our offices, Mumbai, Delhi, Chennai, and Kolkata. This is our training center where we are giving free trainings, half day trainings, full day trainings, 1 week or 1 month trainings to the faculties, students, and even the foreigners who are having collaboration with us, like WIPO, Japan, USPTO, EPO, different countries. In the summer, we are having summer vacations training. So anybody interested can request us, and we are here to take up the training and guide in the different kind of intellectual property rights. This is our website wherein you are getting all the details about intellectual property in India, that is patents, designs, trademarks, and geography indication on the website www.ipindia.gov.in. We are getting all the information from the filing, forms, fees, and the status of application what you are filing. What is intellectual property? We know we are creating, but we are not putting in the form of obtaining the right for that. Something which is come out of your mind, that is an intellectual property. That may be in the form of songs, writing the books, or any product or a process which you can develop on by thinking yourself. When you can get an thinking or solution to your problems. When you are sitting in the colleges teaching or in the public, by knowing the daily problems, we can get solution over that. For example, last January 2020, we are getting the problem of COVID virus, but still many universities in the foreign, companies like Bharat Vaccine, Shanta Biotech, Serum Institute, many are working on that, but only few have come up with the solutions that human trials are going on. That is a problem. By thinking, by doing some practical, they got a solution. But in Ayurveda, many people told that if you take the extracts of different medicinal plants with the spices, you can get rid of your respiratory problems, because COVID is nothing, it's attacking the respiratory tract system. So these are giving solutions, but what exactly they are coming in the form of product, that is composition, then it can be filed. Another example is, as we know that in our daily uses, we are using our gas cylinders in the home, but nobody has fitted the knob to that so that it indicates the how much gas remains. What we do, still in the 21st century, we are advanced with our computer technology. We again lift our cylinders, see how much gas remains, so that you will not get the problem. We will book the gas before at the time of it exists. What is this? Again, we are using manually, being in 21st century. Why can't we come with a solution to find that some indicator which can indicates 1 kilo gas is remaining, this much is remaining, this much, so that we can book before it completes. So this again, we are using some manual things being in the 21st century. These are the problems, but still we are not coming up the solution for that. So if you discuss, definitely we'll get a problem solution approach. What are the different kind of intellectual properties? There are two kind of intellectual properties: tangible, intangible. People, those who are intangible properties like car, buildings, golds, what they think, we are rich enough in the society. But it's not like that. The intellectual property is another kind of property which can give you a asset like other form of property or more than that, because you are developing technology. By licensing, you can get royalty and you can earn like anything as compared to the other kind of properties. In this again, industrial property, copyrights, wherein industrial property includes patents, design, trademarks, and geography indication. Let us see one by one different kind of intellectual property rights. What is intellectual property? It's an intangible creations of human intellect having commercial value, asset like any other form of property. Why you're comparing? Because it's giving return like your other form of property or more than that, I can say. Therefore, it's called an asset like a other form of property. It's different kind of intellectual rights are exclusive right, because once you are getting a patent on your name, trademark on your name, or design or copyright, you are your own, you can exclusively enjoy the right of that, prevent other from selling, buying, or doing many things. So it's called as exclusive right, or it also called as negative right, because only you can enjoy, other may not. Another kind is territorial rights because patent is valid only in India if you are filing in India only. If you want to get a right in the other countries, you are supposed to file through patent cooperation treaty, that is called PCT, or by means of conventional country route. So patent always you are filing India means you are getting the right only in India. It's an licensable right because once it registers on your name, you can license to anyone whom you are interested. Therefore, it's called as licensable right. What is the significance of intellectual property rights? It avoids duplication of research, encourages the wide variety of intellectual goods, improve existing technology to produce better and cheaper products. For example, you are sitting in Bangalore, somebody sitting at Hyderabad are working on the same topic knowingly or unknowingly. If you would have filed a provisional application or an application in the published, then somebody would have got that what the other universities, other colleges, other companies are doing in the same field. Therefore, once you are filing the application, it will publish and it will come to know everyone what research is filed by the Christian College University. Until unless you not publish or file in patent application, it will not be published. It avoids, it will be duplicating and you will waste of chemical, manpower, and intellectuals which is going waste. Utilize the published patent and special. Before going your research, always try to study what is published so that you can choose a next topic to file in patent application or to carry out your own research because many B fellow are supposed to produce their project in the final year. PG students are supposed to file their project in there. MP student has to write their thesis, even PG students. So before take your topic, go on search in the patent database so that you will get the way to choose your topics. In the respective field, that may be mechanical, electrical, electronics, physics, biotechnology, chemistry, micro, depend upon the field you can go for the search. Putting your the words which your topic is interested and see how much literature survey that is called prior art in the field of patents. So, and you can get new work done and you can get a reward as an exclusive right because you are filing the patent. Get profit on royalty. Again, put your invention in the technology transfer and get license and be a benefited person among other people in the society. What is patents? It's an exclusive monopoly privilege or right granted by government to the patentee for 20 years from the date of filing or priority for commercial gain in concession of full disclosure of his invention as a territorial right, not worldwide. Means we are doing some research. Government is giving 20 years right on that when you are disclosing everything details because many professors will come to us asking the guidance. They says that my copy invention is this one, but we don't want to disclose you because you may copy. It's not like that. Once you are filing in our office, time in seconds we calculate on writing your file when you have filed the application, and it will be not disclosed to anyone else until it goes for the publication. What is the difference between discovery and invention? Discovery means finding or exploring something which is already existing. Discovery has such no technical effect. For example, you are isolating microorganisms from the cement industry, jute industry, or from some other area. That is just you are isolating, but the method of which you are designing for isolation, use of media, pH, temperature, that's itself, if they are not in the literature survey, the process of isolation can be new, you can file a patent application. If you are discovering a metal from the earth, that's an metal as such is discovery because it is we know metals are there. Already some metals are we in the periodic table we have seen that they have been given name, their weight, all details, but still somebody is bringing new, that's an discovery only because it's present in the nature. But the method which you are applying for the isolation of that metal is patentable. What is invention then? It's a new product or a process. If you want to file invention, it should be a product or process. Again, it should be an useful, novel, and non-obvious to and not public knowledge before the date of filing the patent application. How to achieve the invention? While carry out your research, identify some problem, that any kind of problem. For example, at present is COVID problem. So even a biotechnologist, microbiologist, pharmacist can try for that by doing with the different medicinal plants and bringing in the form of composition. Solve that problem and you can apply for the patent. That is a problem solution approach kind of patents. There are many things still yet to come. The process of purification of an alcohol, the process of preparation of beverages from the sugar molasses. These are all already known in the market. But if you are designing new process which can give you 99.99 purity, that is new because you are changing in the process parameters and you are getting the good result. So always identify the problem and you can get the solution over that. I'll give the simple example in the year 1822. Mr. C.A. Busher has filed a patent for sharpener, writing that tool for sharpening a pencil, writing point away by saving away its own surface. If you would have thought, are very simple at that time, he would have not got patent for that. But at that time, this is a new technology. But no, the term of this patent expired. Anyone company is manufacturing and they are coming in the market because the term of patent is 20 years and that is expired. Another example is electric bulb, which is filed by Alva Edison in the year 1878. After that, we are not keeping quiet because this technology of electricity is in the year 1878. But many LED bulbs come in the market. Why? They are doing improvement over the technology, what is there exists in the nature since 1878. And they are getting patent for different electrical inventions because they are doing mere arrangement, not an improvement over that, or new, which is useful, and they are qualifying the definition of novelty, invention, and industry applications to get a patent. Another example is telephone. Since 1876, this technology is patented by the Alexander Graham Bell. But what was the problem with this one? To connect our near ones or dear ones, we are supposed to dial 10 times. This is a drawback of this telephone. Then researcher has not kept quiet. They brought the phone which is having numbers. Directly they can dial the numbers 1, 2, 3, 4, 5 like that. Again, there was a problem for again that phone. What is that? We cannot carry that phone from connected area to the hall, kitchen, or bedroom. So again, inventors, scientists has thought and they bought cordless phone, which is very long. We can take from hall to kitchen, drawing rooms, or nearby areas where phone is connected, but not far away to the meeting and all. Again, there was a drawback. Then we came in the form of mobile in the year 2000, and everyone is using since after 2005 common. Nowadays, everyone is having 2233 mobiles. What is this? This is technology which they are improving over the technology which is there in the 1870s. Always don't think that telephone is known, so what I can do invention in that. So these are the versions of that technology which has been patented. Different mobiles, you can see Nokia, Samsung. What is this? This is the advanced version of the telephone which is existing in the year 1876. Let us go 1876, 19 era. In 1994, recent example, Bluetooth was not in, but our Indian nobody thought of doing research and get something solution to data transfer. But here, Job Hudson has done invention in the year 1994. He got patent for the Bluetooth. Most common mistakes by the inventors. They publish their invention before the filing date of application. Always try to use your inventions, maintain the secrecy, and before filing the patent application. Wait until the invention is fully developed for commercialization before applying the patent. Because once you know you are doing something new, so don't disclose in conferences or in some, you don't give lecture on the topic until unless you file the patent application. What are designs now? Design is a safe configuration, pattern, ornament, or composition of lines or colors or combination thereof applied to any article, 2D or 3D or in both the form. This is watch, iron box, and camera are different designs. These are registered designs. Applicable, appealable to the eyes, beautifying and product attract to consumer. This is a cup set which looks very beautiful because of flower designs with a different colors model. This is an beautifying product. We are not giving degeneration to the functional or technical feature of the article, but only the aesthetic view of or how it looks, that is registered. The term of design is 10 years. It can be extended for 5 years and total term is 15 years. We can see now everybody is using to sanitize our hand. This is a design register. We can see pharmaceutical designs, ampoules, capsules, bottles, this thermometer which can be daily using in our offices nowadays because of COVID to measure our temperatures. These are all registered. In textile designs, jewelries, these are all registered designs. So if you can design something in the field of textile, pharmacy, jewelry, and you can register and you can get a 15 years time to enjoy the right, means you can sell it and get a royalty on that. What is trademark? It's a visual symbol which may be a word, name, brand, numerical or combination of colors to indicate the source of the goods, to distinguish from the goods of the others, or it gives the authenticity of the goods. Means by name itself, Reliance Fresh, we think it's very good. It's a good product. Why? Because it's already branded. Britannia, Parle-G is good. Amazon is the company which we can buy the goods from that. So we know because these are become famous by branding, by they are registered their trademark. It advertises the goods and services, protect the innocent public from buying goods of second-rate quality. R with encircled is a registered trademark. TM means trademark applied for. Duration of registration is 10 years, can be renewed every 10 years subject to the uses. We see many products which are coming in the market in duplicate rate. Adidas is a huge company, changing their spelling or a type, what it register, they are coming in the duplicate and we are buying that. So we should see what exactly the symbol of Adidas, what is his trademark, then we can buy, because otherwise innocent public will go taking the second rate of quality. What is geography indication? Place names used to identify the source of origin, quality, reputation, or other characteristics of the products. Example, Darjeeling tea, Kanchipuram silk sari, Kolhapuri chappal, Agra peda, Nagpur oranges. The term of this is 10 years. Here, difference that different this joy is filed by a group of people or Astina farmers or the Astina people who are working in the same field, wherein patents, designs, trademarks are filed by individual or combination with the others, that may be other person or company. What are copyrights? Provide its holder the right to restrict unauthorized copying and reproduction of an original expression, literary work, movie, music, painting, software. The term of protection is granted in life of the author plus 6 days. We know that many authors have died even though they are getting royalty for their books. Many singers have died, but they are getting many royalty for their songs which they sung. So this is the because of the lifetime of a protection of the copyright. This difference which I give for the technology, only you are getting the patent, that may product or process. Designs of different kind, you can see the mobiles which are there in your hand with compared to your colleagues, those who will beside you and here and there. Design is different if you compare to Oppo, Nokia, Samsung, many other different, because that is design is already registered. And different name, Bata, Tata, Bisleri, Maruti Suzuki, Mahindra, these are registered. Copyright is for the books. How the intellectual properties are interlinked with each other. You can see this is an example of a Sony TV. Everyone knows that before LED, we are having this type of Sony TV because of clarity. We are very used to buy the Sony TVs. Sony, the trade name or we can say trademark is already protected, wherein the invention remote control mechanism of this TV, by sitting on sofa set, we are operating the TV. That is an technology got patented. Aesthetic view of this TV is also registered by that company. and the instruction of the manual which are there in the TV box are also protected by the copyright. So single product, you are getting protection by different kind of intellectual property, so that your competitor, those who is in the market, will not copy anything among your technology, because you got patent, design, trademark, even the copyright too. Another example is regarding trade secret. Here we know we can taste pizza from different hotels to hotels or Pizza Huts. Taste is different. Why? That is trade secret. That is because this is the agreement made between the people who work in that particular hotels or Pizza Huts, that they should not disclose anywhere. That is called trade secret. There is something adding secret to this ingredient, so that we are getting the taste of that pizza is different. Trademark is the name of that company or hotel. Design is how you are making the pizza, what type of shape. Patents for the technology, what you are using to make the dough fluffy, or the process of making the dough fluffy, maybe by adding some ingredients with the dough, you can. And the copyright for the instruction, what is there in the pizza box. So single product is protected by the different intellectual property. Again, we take the example of the mobiles. We are having Samsung, trademark register, Nokia register. Again, Oppo is also a register. Whereas in design, all also registered with different designs for the different mobiles. Patents for the technology, combination of the software with the hardware with different megapixel camera, we are having the technology different, that is also got patented. And the instruction in the box is called copyright. So even the mobile company also, they cannot copy each other's technology or design or the instruction among themselves. Therefore, they are protecting their IPR and coming in the market, so that they can only enjoy getting the royalty in the market. What can we do with IPR? If some students are listening my lecture, keep in mind what they can do by knowing the IPR. You can become a patent agent if you are a science graduate, that may be BSc, Pharma, or any type of science, plain science graduate, BC and all. If you are a lawyer, you can become a trademark and copyright agent. You can work in the IPR policy, IPR cell, NGO firms who facilitate between inventor and the government of India. Again, we know there are many IPR firms in every metro. You can work in the IPR firms. They act as a facilitator between government of India to the inventors, those who are doing invention, or you can join to the government offices, depend upon the qualifying criteria of the government office, that is patent office. Thousands of scientists and faculty and students can also become inventor by simple approach, what I told you. Try to disclose problem and find a solution for that. And always don't forget to take a non-disclosure agreement between the colleagues who are working with you in the lab or in the college or in the company. Every country is having different criteria of patentability, because USA is giving method of treatment and also giving software as such. But in India, we are not giving patent for that. Let us see what is patentable in India. As per Section 3 of the Patent Act 1970 as amended, an invention which is frivolous invention contrary to the well-established naturalist law are not patentable. Example, motion that gives more than 100 performance. We know only we can get 100% performance or less than that, but not more than that. Machine are used to be giving output without any input. Every machine is require input. This is frivolous invention are not patentable. As per Section 3B, an invention, primary or intended use or commercial exploitation of which could be contrary to the public order or morality, which causes serious prejudice to human, animal, or plant life or health, or to the environment, is not patentable. Example, gambling machines, device for combating theft, device for housebreaking, or method of adulteration now is not patentable. Mere discovery of scientific principle or the formulation of abstract of theory or discovery of any living thing or non-living thing is not patentable because these are considered to be a discovery until it leads to a practical application to the process of manufacture of an article, substance, it may be patentable. Example, isolated microorganisms are, I already told, not patentable. Wherein, as per section 3D of the Patent Act, mere discovery of known new form of a known substance which does not result in the enhancement of known efficacy of that substance, or the mere discovery of any new property or new use of a known substance, or the mere use of a known process or machine, unless such known process results in a new product, are not patentable. For example, stars, ethers, derivatives, isomers are not patentable because you have to prove their efficacy. I quote here my own example here is that in 2015, I rejected the drug tofacitinib, which is filed for the rheumatoid arthritis, filed by the Pfizer US company. They failed to prove how it fulfills the requirement of Section 3D of the Patent Act by showing the efficacy over the base compound. Therefore, in 2015, I given the decision that the drug is not fulfilling the requirement of Section 3D. Therefore, I refuse this application. You can check in the net. Pfizer drug rejected by Bharat NS. You will get all the details about the decision of my drug. Another Section 3, a substance obtained by mere admixture or resulting only in the aggregation of the properties of the component thereof or a process of producing such substance is not patentable. For example, composition of two drugs which were already known in the market, that is paracetamol and brufen. Paracetamol is an antipyretic, brufen is an analgesic. But if you are combining both the drugs and bringing a single capsule, that is just you are making a composition but not giving the synergistic effect. You are claiming that both the drugs are independently known. Therefore, such type of mixtures are not patentable. As per section 3F, mere arrangement, rearrangement, or duplication of known device, each functioning independently of one another in known way is not patentable. Because example is bucket fitted with a torch. If you're going in the dark to bring in water in the villages and you're solving that, you are fitting torch to the bucket, is not invention. You are solving your own problem, and because both bucket is different, torch is different technology, and both are known in the prior art and the public, and you are making the arrangement just. For walking in the hot summer, holding umbrella in the hand and fitting a fan with that to feel cool yourself, that is not invention. You are making arrangement or rearrangement of your known devices independently. Such type of inventions are not patentable. As per section 3H, method of agriculture or method of horticulture is not patentable. For example, method of producing plant, method of producing improved soil, method of producing mushroom, algae is not patentable. However, the instrument which are used in the equipment which are used in the agriculture industry are patentable, like tractors or many food grain threshing machines are coming in the agriculture. Different kind of equipments are coming. Those are in the form of product, they can be patentable. As per section 3I, any process for medicinal, surgical, curative, prophylactic, diagnostic, therapeutic, or other treatment of human beings, or any process for a similar treatment of animals to render them free of disease or to increase their economic value or that of their products are not patentable under section 3I. Example, process of administering vaccine or oral treatment or method of cleaning dental plaque, method of vaccination are not patentable. However, manufacture of artificial limbs, device for surgery, diagnostics are patentable, like X-ray machine, any other kind of machines are patentable. As per section 3J, plants, animals in whole or any part thereof other than microorganisms but including seeds, varieties and species and essentially biology processes are not patentable, which are used for the propagation of plants and animals. Wherein these plants variety protection in India under the provision of the Protection of Plant Varieties and Farmers' Right Act 2002. As per section 3K, mathematical method or a business method or algorithm or a computer program per se is not patentable. A literary, dramatic, musical, artistic work or any other aesthetic creation including cinematograph work and television productions are got under the copyright, not comes under the patents. As per section 3M, mere scheme or rule or method of performing mental act or method of playing game is considered as a outcome of mere mental process, not an invention, hence not patentable. Example, method of learning languages, method of teaching, method of solving cross puzzle, method of playing chess, method of operating a machine as per the set of instruction are not patentable. Presentation of information is not patentable. As we see, railway timetable is since 100 years time we are using, but still is an way of presentation of information, not an invention at all, therefore not patentable. Topography of integrated circuits is also not patentable. It is dealt by another act that is called Semiconductor Integrated Circuit Layout Design Act 2000. As per section 3P, an invention which in effect is traditional knowledge, which in aggregation or duplication of known properties are not patentable. For example, turmeric powder in wound healing. We know our ancestors used to use the turmeric whenever we are having cuts on your hands or fingers because it has an medicinal value. The pesticide and insecticidal properties of neem. We might have, if you are remember in villages, they used to store their food grains by applying the dried leaves of neem because it's having insecticidal properties. We have not came to the chemical identification, but as such plants also show some activity. Therefore, such type of inventions are not patentable. Our examiners, if you are filing the inventions related to intellectual property, they do the research in the TKDL library and they will see whether it's false within the purview of this provision or not. If it's not false, then you will get the patent. If it is falling under section TKDL of 3P, then you will not get patent for traditional knowledge. And again, what can be patented in India? Only inventions can be patented in India, which are new, which are not published, otherwise disclosed to the public before the date of filing of the patent application. Inventive step is another requirement. That is a technical advancement as compared to the existing knowledge. What is there in the public knowledge, you have to do something technical advancement. It should have economic significance or both. That makes the invention not obvious to a person skilled in the art. Means, how can you judge it's an inventive over the public domain or literature survey which is there in the public? It should give surprising result. The solution to a long-standing problem, the fulfillment of a long-felt need, or it should have a great technical progress. Something there, for example, COVID vaccine is not there, but you are solving that and you are getting a solution for that. That is an invention. I told you for gas cylinder, there is no knob. If somebody comes with a knob, indicates the how much gas. That is a long-felt need of the every people who, and that is a solution for that. The conversion of an wind energy into electric energy is a long-felt need. If you are getting great equipments or machines to convert that wind energy into electrical, that is a long-felt need of everyone because we want to get into renewable energy sources which will not exist at all because wind always blow. We can convert always wind energy into electrical energy. There are different kind of applications that is called provisional and complete. Provisional means as soon as the idea comes to your mind, you can file the application that is called provisional application. Complete means you have to complete your whole research, practicals, examples, and you have to come into the conclusion of that. That is called complete application. Why? Everyone files a provisional application because It saves priority of invention, get extra time for further development, disclose to interested person to obtain financial support. Once you are filing provisional application in your office, we are getting a receipt that you have filed the application. You can take the receipt. Same project you can write to the UGC. You can get a financial support to complete your invention. Explore commercial feasibility. If it is not having worth, you can stop even doing the more work in the patents. Therefore, they will file the provisional application. What is the complete application content? If you are filing the complete application, what should be there in the application? Like our thesis, which is your title, literature survey, experimental details, findings, conclusions, and then we write what we achieved from that. Same way, here is the criteria to write complete application. That is, it should have title of invention, prior art that we call as literature survey, drawbacks in the prior art, what was there in the drawback, efforts or solutions to bring the solution for the problem, summary of the invention, what you are doing, statement of the invention, what exactly you did, description, drawings, if it is mechanical, electrical, physics, sequences, if it is in biological, microbiological, or biotechnology invention, give the examples, then file the claims. That is the end of the application. Always, main description should be clear, concise, fully, and claim should be at least every application should have one or more than that claim as per section 10(4) of the Patent Act. What is the objective of the claims? To define clearly, precisely, you should require a claim, define the scope of the invention, define various necessary features of the invention to limit, not to extend the nature or scope of the invention. Should be fairly based on the matter. What you are doing invention, on the same invention only you can file the claims. Principal claim should define all the essential novel feature with the interconnections. Preferred or optional feature may be given in subordinate claims. How the claims are: the process of preparation of cyclosporine, the process of preparation of alcohol, the process of preparation of paracetamol. This is the title we are giving. And the other feature, the process as claim in wherein other parameters you can. This is called independent claims, and which you are making dependent on a number claim 1, that all the features are defined in the dependent claims. One example I give here, a simple example. You can take your pen in the hand if you're having with your jibs. A foldable pen. Title is foldable pen. Means you can assume how the pen is, how the written application in that kind. Is it drawing of the pen? Complete application. Applicant's name is so and so. Address so is so, Kurukshetra, Indian. And preamble is the following specification particularly describe the nature of his invention and the manner in which to be performed. This is the section or form 2 standard preamble of the complete application. We have to give present invention relates to foldable pen, how the pen is, then background, how other pens are, then disadvantage, what was the disadvantage of earlier pen, so that he is bringing the foldable pen, summary of the invention, advantage of present invention over the prior art, statement of the invention. What is exactly he's having? He's having foldable pen, comprises flat body, again hollow reservoirs and writing. It is having 3 parts. You can check: hollow body, ink reservoir, and dispensable ink, that is tip of the pen. We can say these are the, and he's giving each part drawings what figure 1 is, figure 2 is, figure 3 is. Again, how they are interlinked with each other to carry the function of writing, they are mentioning here details. And lastly, they are claiming that a foldable pen comprising flat body of quadrilateral shape, molded to form 2 longitudinal depressions, side depression acting as hinges, and defining 3 panels such that the body may assume 2 distinct shapes, either virtually flat, quadrilateral, object, or when folded it says free zone. Again, second part is hollow reservoir located in one of the panels. Third is a rate into deep. This is a single claim. This is called as principal claim. Another part is a foldable pen as claim 1 wherein the panel is of the same size. Foldable pen as claim 1 wherein panel is beveled. Foldable pen as claim other parameters he is disclosing all details. Lastly, foldable pen as claim 1 wherein the pen tip is a felt tip. He is telling all how the pen is. Date, signature of the applicant, it should be given. Another example I'll give you here is a herbal invention. He is telling that why is coming to herbal invention? Because there is a allopathy treatment for Parkinson's disease, but it is having a side effects and more costs. Therefore, he is coming in the form of a commercially he is bringing the herbal solution. What he is doing? He is doing the treatment. He is considering the Atmagandha plant and he is telling that how it is effective. He is telling that earlier treatment are expensive, having side effects such as gastrointestinal, like nausea, anorexia, cardiac irregularities, and orthostatic hypotension, weight gain, psychiatric symptoms such as agitation, hallucination, deletions, are side effects. Therefore, it's coming to the Ayurvedic invention. What is its objective? To provide an invention which is a diuretic tonic and readily soluble in water and delicious and flavorous. Here, what he is doing is selecting the ripened seeds of Mucuna bark, violet bean plant, pulverizing the seeds of Mucuna into the fine powder and then mixing it 80 to 90% and the other formulation 20 to 10% with the antioxidants. So what he is doing that exactly giving the detailed information about the invention. Again, he is claiming the process of preparation of an formulation for treatment of Parkinson's disease by selecting, polarizing, and mixing. These are the steps of his invention. And seed powder is 90%, antioxidant 5%, stabilizer 5% with the vitamin C and E to make his tonic good. And flavorous. He is adding these vitamins and vitamins for the good palatable. This is the way. Lastly, we have to sign and date at the end of the application. If you are writing on your own, you have to sign. If you are authorizing some agent will sign this. These are the writing of the compound claims of Formula 1, wherein A is this. If you are dealing with a compound invention. If you are doing process of preparing, I told you Ayurvedic medicine, this process of preparation a compound. This is a way of writing pharmaceutical composition, which comprise agilestin or salt thereof, steroid composition being in the form of suitable nasal, ocular administration, and detail how it is used that is given. This invention is filed by the Cipla company. Another example, as in India, we are using many pets in our cities, but always if rain comes, we rush under the tree or we see some shelter. But there is an invention that Anthony Sisles has filed invention for dog umbrella. If rain comes, you can put the umbrella. That's an invention filed by US people, and he is getting benefit out of that. Many are buying this dog. Dog waste catcher and holder. It's carried a dog's owner to create while he or she goes to walk. We think Indian mentality, they should not do excrete in our campus. They can go out on the road, they make their dog to excrete. It's not a good mentality. Where in US, we are having the invention to a stick which can hold the motion or excrete of a dog by placing that instrument under the dog's whenever it feels to be getting and excreting the waste. The plastic badge is then they are holding, and the plastic badge they are removing, and this is the way of sanitary and to keep the environment clean. Another example is an enhanced fish attractor device. In India, we are being coastal side people. Many people slyly die fish depend upon that. Still, we are using the net to catch the fishes. But here is the Brughoff's Gray has filed an invention for enhanced fish attractor device where easily he can get the fishes by using this device. Where our Indians still we are following the nets to catch the fishes. How to file a patent application and where to file. Any person can file a patent application. Small entity, natural person, or startup can file a patent application. You can file physically visiting the office, or you can file online also. Depend upon the jurisdiction from where your invention originates, you are supposed to file. For example, Mumbai, the state of Gujarat can file, Madhya Pradesh can file, Chhattisgarh file, Union Territories. Wherein Karnataka people like Telangana, Lakshadweep, they are supposed to file in Chennai because it's all based on the jurisdiction where inventor resides or the invention from where it originates or address of service from where you are giving, you have to file. What are the minimum documents required for filing? Form 1, Form 2, provisional complete application, Form 3, Form 5 for declaration of inventorship, request for that is on Form 18 for examination, abstracts and fees you can file. If you want express publication, Form 9. If you are authorizing agent, Form 26 is required. If you are filing patent application 1,600 for a natural person and 8,000 for the company up to 30 pages of the application. For exceeding more than 10 claims, 160 per claim for individual and 800 for the company. If you are exceeding more than 10 claims, 320 for the company, individual, and again 800 for the company. So this is the way of the fees which are charged for the each and every individual. If you are filing request for examination, 4/3 for natural person, 20,000 for the individual. If you are filing physically, you will get additional 10% of that. Form 9 for early publication. Once published, your name will come, title, date, applicant, and abstract of invention. By reading this, anyone can understand what is invention. There are various forms you can get from ipindia.nic.in and you can file a patent application. If you want to file online, you can go in ipindia.gov.in, but you should have a digital signature to file a patent application. How the office procedure is to grant the application. Once you are filing the patent application, it's go for digitization, screening and classification. Then it's early publication if you are requesting, or it will be 18-month publication as per normally. Any person can file opposition once it's published, and we will take into consideration during the hearing. If you have filed a request, go for the allotment. Exam will give FER, you are supposed to reply within 6 months. If you are not able to reply, you can obtain an extension by filing for Form 4 of 3 months. Within 9 months, you are supposed to reply. Once you have filed reply, if this reply is satisfactory, then it go for grant. If it's not satisfactory, go for the refusal. Once it's granted, it will again go for the post and publication. From 1 year, any interested person can file an opposition again. Means it is two-tier system to grant a patent. Once you can, by way of presentation, another is by interested person only file opposition. Once opposition comes, we consider the opposition board. They will give the recommendation whether opposition file is valid or not. Taking the consideration of that, applicant's reply, opponent's recommendation, will take all in consideration and will decide whether the application is grantable or refusable. So depend upon the reply of the company or applicant will decide whether the application has to be granted or not. Once reply is satisfactory, we will grant the patent. Before carrying on to research, you can go these sites wherein you can get all the details before you are doing your project. Search on these sites: IPindia, Google Patents, USPTO, EPO, and WIPO search, wherein you can get all the details of the prior public knowledge before start your project. What is the role of intellectual property system? Encourage for improvement of technology. Always you are having this technology, you are encouraging to do a new technology. Providing reward as an exclusive right for disclosure. Making profit, earning royalty through putting the invention to practice. Transferring into public property after expiry of term or session of patents. What are the right of patents? If products prevents other from making, using, or offering for sale, which is process again prevents from others to using. Only government can use freely your invention once you are getting on your name, that is section 47. Only for the experiment and research purpose. The term of patent is 20 years. By knowing different intellectual property rights, that is patents, designs, trademarks, you can share the benefit of patent system to your colleagues, society, to with the other faculties. Wherever you go, you can share the benefit of patent system. Utilize the resource through organization, organize R&D activities, capture global market judicial limits, getting a different copyright patent, design, trademark, GI, you can come in the market. So you are capturing your market judicially, means where nobody can copy your name and fame, earn profit through the protected market. Thank you so much. Any questions?
Thank you so much, sir, for the informative session on IPR and patent process. We have several participants who have joined. If you have any questions, inquiries, you can ask. Those who are listening through uh, YouTube also, you can join the link which has already been sent to your email. You can join the link and you can help your doubts. It's open for questions now.
Any question, please? Don't hesitate to ask the questions.
So just you can give just a general overview on how this IPR and patent will be useful for different disciplines like you have commerce, you have management, you have sciences, you have arts. So how we can benefit.
See, arts people are not having much, but they can do trademark. If you are designing there for own startup companies, and they can design their own trademark, they can design the registration for the designs. Different kind of design they can come in the pharma, textile, or any kind of jewelry design. For commerce, the method of business what they are doing. Before that, they can protect their logo, name, or they can become agent for that, also doing copyright registration. They can write books, songs, they can get. But in science, we are having lot in patents. Whatever technology they are developing, they are supposed to file the patent application. That means simple. You can go any problem which is there. For example, the process of purification of air by developing some genetically modified microorganism. It's a new one. It's not there in anywhere. You can file. There are many places where we can get a directly the method of purification of an many waste of water in the locality. We are seeing how garbage is getting smell. So use some biological method to treat that waste. There's an invention. Small scale industry can use it. The method of preparing an beverages from the locally used vegetables. How you are able to do? You can do. Food grains you can develop. So these are simple way you have to bring in the small scale industry of working on this type of invention. You can come many herbal products are there in India. Still nobody had touched on that topic. Medicinal plants are there. They are in the literature survey, but nobody brought in the form of composition, tonic, or medicine. So there is a lot world is required to be researched. Still, we are starting research in the IPR. Many of still not know what is IPR, how to file also. So this is overall I have given. If anyone interested, again that particular for PG, for lectures, you can take paid of half day or full day. We will know detail each word. It's just I rushed because patent is not a subject. Since 17 years I am in the field, still many things which I may not have knowing, because somebody may ask something new question that I may not be able to answer, because it's a learning process. IPR is developing, it's evolving day by day. So depend upon the field and faculty, they have to choose whether they have to go for patenting, design registration, trademark, or they have to go for the copyright material, any idea if they are getting. So this is the overview of everyone.
There are a few questions in the chat box also. Like there's one question: how long does it take to register a patent?
Yeah, it requires 18 months for publication. If you are requesting normally, again 6 months is required. 24 months you will getting patent. If you are expressing very early, within 6 months also you can get patent, because you are paying more fees. That is called expedite examination. You have to pay 60,000 for the company and for 8,000 something for the individual. If you are paying more fees, that is called expedite examination. And there is a criteria who can file expedite examination. Only startup, MSc or the applicant who is one of the lady among the applicants, or government institute or university can apply for that. So within 6 months to 1 year, up to 24 months, you can get a patent for that. Any
And the newly invented plant variety, whether it can be patented, newly invented plant variety.
newly invented variety is not got the patent, but it will be protected under the patents, not patent, but it's a Plant Breeders' Right Act 2002. It is dealt separately. The procedure is also separately for the registration of the plant varieties related one.
Thank you, sir. So any more questions? Those who are in the link in the Google Meet, you can ask any questions you may have.
Anyone, please? You can, if you are not able to ask, you can chart in the box so that somebody will read for me.
So you can speak on the funding of the CPR, what teachers, faculties, our PG students, or
as such, our patent office will not fund anything. We are not funding for any, but we are giving facility that if you are MSME, startup, or small scale industries, they are coming. If you are authorizing, we are paying all the fees which you are getting for that, like 10,000 for authorizing agent. That fees government will give you. That's all. But funding all done by the different universities, that is UGC project, or companies. For example, you are working on the COVID composition. So if you are working on biotechnologically, in biotech company interested can, if you write the project to them, they will fund it. If you are working on herbal, then herbal industry will depend on the topic which are. If you are working on allopathic, any pharma company can guide you on project, because still it's a lot research yet to do on COVID virus. So you can do in such kind in many other, like oil eating bacteria. Many where we are seeing oil is spilling more in the oceans. Many companies still it is polluting our ocean, but we require genetic technology or biotechnology which can absorb the oil which is there in the seashores and all, so that it is genetically modified. So same company can offer, but we being the patent office are not funding for any projects.
Thank you, sir. This is the last call for any questions.
Yeah.
Can intervention methodologies be patented? This is one question, sir. So there's a question.
Yeah.
Can intervention methodologies be patented?
Which one? Intervention.
Intervention methodologies be patented.
Intervention means which kind of methodology? Please, can explain just one or two example they can give? Who has
Like psychological intervention is one question asked.
No.
Can a psychological intervention?
No, psychological comes under the method of treatment. If your psychology is you are studying and doing something that leads to a making free from a disease for that person, that is comes under the method of treatment. Hence, in India, as per Patent Act 1970, 3I section deal with this, and it will not give the patent for that. But wherein US is giving for this type of treatment patent. Anyone, please?
So if you have any further questions, you can also afterwards send a mail to QC.
Yes, you can send anytime.
Send it to you. So we'll be glad to clarify your doubts. Okay. So as we conclude the webinar, I thank Dr. Bharat N Suryawanshi, Controller of Rajiv Gandhi National Institute of Intellectual Property Management. Sir, thank you very much for your time with us. And that was a very informative session, very efficiently was presented, and a lot of insights were given and patent process. So we hope to have many more such sessions in the future, and to have more awareness programs on IPR and patent process. Once again, on behalf of Christ Academy Institute for Advanced Studies, management, faculty, and student community, I extend heartfelt thanks to you, sir.
Thank you so much. Thank you for everyone.
I
Any doubts?
also thank all participants who have joined in Google Meeting and also those who are watching through YouTube online. Thank you so much for your time, and we'll be in touch with you for further programs. We'll communicate to you for any
Thank you.
such extension of the programs. Thank you so much
Yes.
to all the participants.
Thank you, sir. Thank you. Bye bye. Good day.